Welcome back. This is American Jurisprudence Part 2. I'm Catherine Biondo. I'm a legal reference librarian here at Northeastern. In this lesson, I'll cover what is common law, court hierarchy, jurisdiction, mandatory versus persuasive authority, dual court systems, and the doctrine of stare decisis. The concept of common law is sometimes confusing because of the duality of meaning. Common law may refer to a system of law as opposed to civil law. In common law systems, of which the United States is one, courts rely on precedent, formal determinations from earlier cases. In civil law systems, many European countries, Latin American countries, and Louisiana, courts rely more on codes providing specific rules for handling certain types of disputes. Common law may also refer to case law or judge-made law. A case is a set of legal determinations made about particular facts involving parties with a genuine interest in the controversy. Judge-made law may be based on interpretation of a statute, which is law made by legislature. Interpretation of a constitution, whether it's the United States Constitution or a state constitution. If it's neither of these two, it may be what's referred to as judicially created doctrine, purely decisional law based on precedent, policy, and fairness. The American legal system is based on a system of federalism, which refers to shared powers among the state and federal governments. The federal government has certain limited powers prescribed in the U.S. Constitution. The states retain all the powers that are not expressly left exclusively to the federal government. The federal government and most state governments have court systems based on 3 tiers. The lower courts are fact-finding bodies. The intermediate courts hear appeals from the lower court, and the high court hears appeals from the intermediate court. Cases proceed from the lowest level to the 2 separate levels of appeal. Note that a few states have only trial-level court and 1 level of appeal. Here's an example of the federal and state system. In the federal system, the lower trial court are the U.S. district courts. Appeals are taken from there to the intermediate appellate court, which is the U.S. Court of Appeals, and from there to the highest appellate court, which is the U.S. Supreme Court. In the state example, Massachusetts, cases are appealed from the trial court, the Massachusetts Superior Court, to the Massachusetts Appeals Court, and at the highest level to the Massachusetts Supreme Judicial Court. Note that in some instances, appeals may be taken from the highest court in a state to the United States Supreme Court. So jurisdiction, what type of cases may federal courts and state courts hear? Federal courts may hear questions of federal question jurisdiction, statute and constitutional issues. Diversity cases, disputes between citizens of different U.S. states or against a foreign citizen, provided that a certain monetary threshold is met. Cases in which the United States is a party, and other matters as specified by law, so admiralty, antitrust, maritime. There may also be matters of removal jurisdiction. In other words, if the plaintiff could have brought the case in federal court, but brought the case in state court, the defendant can remove the case to federal court unless the case is in the defendant's home state. What can state courts hear? Well, essentially anything, including those matters over which federal courts have jurisdiction, with the exception of where the state jurisdiction is precluded by federal statute. So the doctrine of stare decisis is a fundamental principle of a common law system. Essentially, the stare decisis dictates that like cases should be decided today the same way that they were decided in the past. Let the prior decision stand. This is based on the holding of the case, not the dicta, the holding being the final determination of the case by the court, not the dicta, which is the commentary that's included in the opinion, how the court got to the final determination. We're not interested in that discussion, we're interested in the final determination. Why do we care about stare decisis? Well, because fairness requires that like cases be treated alike. If a judge is basing a case on applicable precedent, it's harder to base it on arbitrary or impermissible criteria. Predictability. We should know how to avoid litigation by knowing exactly what the law is and having that faith that it's going to be applied consistently. And then for judicial efficiency, permitting judges to efficiently resolve cases without reconsidering the issues that are already decided, and also enhance the judiciary's credibility. Stare decisis depends upon jurisdiction, what geographic region are we in, and court hierarchy, what level did the case arise from. Consider when applying stare decisis, is it a factually similar case? Now these are going to apply to factually analogous cases. If a court decides not to follow the doctrine of stare decisis, it's going to distinguish the precedent, essentially saying that it's too distinct from the prior case for the precedent to apply. So again, application of stare decisis. Stare decisis only applies to cases decided in the same jurisdiction by a higher level court. So here the diagram shows that in the state court, Massachusetts' example again, the precedent from the highest court, the Supreme Judicial Court, applies to the Massachusetts Appeals Court, and the Massachusetts Appeals Court to the Massachusetts Superior Court. And the Supreme Judicial Court, as the highest court, also, the precedent also applies to the Massachusetts Superior Court. In the federal system, the United States Supreme Court, down to the United States Court of Appeals, and also applicable to the United States District Courts. Mandatory versus persuasive authority. With mandatory authority, also called binding authority, sometimes called controlling authority, the court must follow that authority. What is binding? Well, applicable constitutions and statutes. In terms of cases, the doctrine of stare decisis applies. Persuasive authority, the court may follow, but is not required to follow. What is considered persuasive? Well, cases that are not binding. In other words, stare decisis does not apply. And any kind of secondary sources. Secondary sources, as you learned in the first American jurisprudence lesson, includes anything that's not law. So all of your encyclopedias and your treatises and any other kind of material that is law review articles, not things that are not cases, not legislation, not administrative law. Why might a court decide that it wants to follow certain law? If it's persuaded by policy or the attractiveness of reasoning. If it's a matter of first impression for a court that this jurisdiction has never considered, it may look to other jurisdictions and may decide that its reasoning is persuasive. Likewise with certain secondary sources. If a particular matter has not been handled before, but a restatement or some other particularly persuasive secondary source, a court may decide to follow. But again, it is not required to do so. Mandatory authority, we see the application of stare decisis in the red lines, meaning that the upper level courts of a jurisdiction are binding upon the lower level courts. Same goes for federal as it goes for state. Now what about between jurisdictions, whether it be between federal jurisdiction and state jurisdiction or two different state jurisdictions? Well, a decision of the highest court in one state is not going to be binding upon the intermediate court of another state, nor is the intermediate court going to be binding upon the trial level of another state. Trial level to trial level is not binding. From federal to state, a decision of the United States Court of Appeals, the intermediate level, will not be binding upon a state's lowest court, nor will one trial level court, the federal trial level, be binding upon the trial level of a state. Now the United States Supreme Court, though, is of course binding upon the intermediate level of a state. And in the case of the United States Supreme Court against the highest court of a state, it depends. If the precedent was issued by the United States Supreme Court, the precedent will be treated as binding on all courts, with the exception of if the Supreme Court precedent involved a matter of state law, it will not be binding upon the highest court of the relevant state. So we'll put a question mark there. Now, as for the Constitution of a state, that of course is binding upon that particular state. So the Massachusetts Constitution is binding upon the state of Massachusetts. Will it be binding upon the state of New York? No. However, the United States Constitution is binding on all states, of course. Now, moving on to persuasive authority, now the red lines show which court's decisions are persuasive upon the other courts. So the lowest court's decisions may be persuasive upon the upper level, and that's the same in each jurisdiction. Now, with persuasive authority, a decision from one state's highest court may be persuasive to another state's highest court. Same goes at the intermediate level or the trial level. From federal to state, the state decisions may be persuasive upon federal jurisdictions. Same goes for highest level courts to lowest level courts in each jurisdiction. Well, that concludes the lesson. If you have any questions, feel free to contact me at the email address here or stop by the 3rd floor of the library. I'd be happy to talk to you and answer any questions that you have. Look forward to seeing you in class. Thanks very much.